The Wiretap Act passed as Title III of the Omnibus Crime Control and Safe Streets Act of 1968. You may hear people refer to it as a wiretap or Title III action, but wiretap was certainly an important aspect of fighting crime in the 50s and 60s. Derived from the Supreme Court's ruling in Katz versus United States that the Fourth Amendment restricts the government's use of wiretaps to eavesdrop on telephone calls. So it contains a broad general prohibition on intentional interception, procurement, and use of electronic wire and oral communications, and prohibits the intentional interception or disclosure of the contents of unlawfully intercepted communications. However, there are a number of exceptions to the Wiretap Act, and that, for instance, if there are a telecommunications employee it needs to listen in on a wire for rendering service or protection of the rights or property of a provider, or providers may provide information to the government as authorized by the FISA court, or you have a law enforcement officer who's a party to the communication and is not subject to the Wiretap Act's prohibitions, or you have a private individual who may intercept a communication if that individual is party to the communication. So the wiretap statute prohibits electronic communications in transit in general. The ECPA amended the federal wiretap statute to include interception of electronic communications, including email. The federal wiretap statute states that immediately upon the execution of the period covered by the wiretap, recording shall be made available to the judge issuing such order and sealed under his direction. The presence of the seal or satisfactory explanation for the absence thereof shall be a prerequisite for the use or the disclosure of the contents of the intercept. The ECPA may give you a pass on analyzing email that is static. Again, that's inside the mailbox. But email and files that are in transit may violate a wiretap statute. The Cybersecurity Act of 2015 also can significantly enhance the ability for private entities to monitor systems and networks for cybersecurity threats. Pen registers are devices or processes that records dialing, routing, addressing, and signaling information of wire and electronic communications. Now, again, these were derived early on when telecommunication systems were analog devices and analog servers, but now they've been adapted to the digital world. The Pen Register Act restricts the collection of non-content communications data by government and private parties, and the U.S. Supreme Court held that the Fourth Amendment does not restrict the government's use of pen registers to obtain content information. So non-content information are things like logs of telephone numbers, metadata, things that do not contain the content of the conversation. Trap and trace devices collect this metadata of incoming communications. And the Pen Register Act does not apply to the contents of the communication. So you can collect the metadata, but you cannot collect the content. A pen register requires a certification from a law enforcement officer that the information is relevant to an ongoing investigation. And that is a pretty lenient bar to meet. So all you have to do is show that it's likely, the information likely to be obtained by such an installation, and you don't even have to show probable cause. A Section 3123 order must specify the identity of the person to whom the telephone line or facility is leased, the identity of the person who is the subject of the investigation, the attributes of the communication for which the order applies, and the statement of offense to which the information is likely to be obtained by the device. So that's all you have to provide to be able to collect that metadata. The ECPA updates the pen trap statute for non-content traffic. can use the pen trap to trace communications over the internet and computer networks. And if the pen order is issued by a federal court, it has validity nationwide, and law enforcement must file a special report with the court. So an interesting concept is that of the national security letters. That's a controversial aspect of the 2001 USA Patriot Act, and it was an extension of the government's ability to issue those letters. They're administrative subpoenas that allow the government to secretly obtain certain information relevant to national security investigations and modified for privacy purposes. But the FBI can provide wire electronic service provider with a name, phone number, and account number, and these letters request the associated name, address, length of service, local and long-distance toll billing records. The service provider additionally cannot reveal the existence of these letters. The Foreign Intelligence Surveillance Act prescribes procedures for physical electronic surveillance and collection of foreign intelligence information between foreign powers and agents of foreign powers. Interestingly enough, it's not just foreign agents, so it may include American citizens and permanent residents suspected of engaging in espionage and violating U.S. law in the territory under United States control. FISA, there's multiple provisions for FISA. There's electronic surveillance, physical searches, pen registers and trap and trace devices, access to certain business records, and reporting requirements. You can read through all of these in the indicated references there. But most importantly with the FISA is the concept of warrantless searches. So the President of the United States may authorize the Attorney General to conduct electronic surveillance for up to 1 year without a warrant. The Attorney General certifies that with the FISA court, but it may also conduct warrantless searches for up to 15 days at the start of a war. So warrant searches may apply for a warrant through the FISA court if they want to execute warrants that are searches that require warrants.